This is now in session. The Honorable Rachel Pickering presiding.
Yes, thank you. Thank you, Judge. You may be seated. Good morning. Welcome to the February 2026 Wichita docket. My name is Judge Rachel Pickering, and I will be your presiding judge here. On my right is the Honorable Amy Klein, and on my left, joining us today, is the Honorable Carrie Hipp. Judge Hipp graduated from Fort Hays State University, and she graduated from the Oklahoma City University School of Law. She began her career at the Sedgwick County District Attorney's Office right here in Wichita. Judge Hipp later moved to Ellsworth, where she worked in prosecution, criminal defense, domestic, government law, before becoming a district court judge in 2019. So we are pleased to have her joining us here today. So for this morning's docket, we will hear 3 cases. We will hear the first 2 and then take a short break and then come back for the third argument. So at this time, I do call the first case, and parties may come to the council's table and get set up, and then we will have appellant make their appearance at the podium. This is Melissa Heinzman versus State of Kansas, appellee.
May it please the court, Your Honor, David Miller.
Oh, it's all right.
I'm sorry.
Are you ready to start your argument?
I am.
You can come to the podium.
Okay. Excuse me. Good morning, Your Honors. David Miller for the appellant, Melissa Heinzman. And I would request of the court 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. This is an appeal from a denial of a KSA 60-1507 petition. The underlying issue was whether Ms. Heinzman's plea was made in a knowing and voluntary fashion due to ineffective assistance of counsel. And the evidence below, we believe, certainly indicated that her plea was not made in a knowing and voluntary fashion. The first, obviously, excuse me, with the Strickland standard, we are dealing with the 2 prongs, deficient performance and prejudice. For the deficient performance prong, we've cited to the United States Supreme Court's decision in Strickland and the progeny of Strickland in many cases flowing from there. The court has indicated that they often look to the ABA guidelines and standards for what is reasonably appropriate attorney conduct. At least that's the guidepost that they look to, and at least the beginning point. And we cited to the criminal defense standards, specifically the ABA criminal defense standards with regard to how counsel, or what counsel should do in a case where ultimately the case ends up in a plea of guilty. And those standards really very emphatically say that, excuse me, the counsel cannot advise a defendant to plead guilty until there has been a thorough review of the law, potential defenses, as well as going over the evidence with the client. And so that we suggest that is the standard, at least for the deficient performance prong in this particular case. And Mr. Landis, Attorney Landis, was the attorney below. Ms. Heinzman initially, I think, had one attorney who met with her one time, and then he left. Mr. Landis took over. I believe his name, the first attorney was Byfield. But Mr. Landis was the attorney that represented Ms. Heinzman at the plea hearing. So she was charged with the knowing ag battery of a law enforcement officer. I'm sure the court's aware, based on the briefs, of the facts of the case, but basically Ms. Heinzman was stopped by law enforcement. The deputy approached, Ms. Heinzman drove off, and, unfortunately, the deputy either got her foot caught in the wheel and apparently was drugged.
So when she was stopped, stopped by an officer who was in a police uniform, is that correct?
That is correct.
And in a patrol car assigned to that police officer?
I believe that's true.
So anybody's being stopped would know it's a police officer that was coming?
Yes, I'd agree. Ms. Heinzman was also testified, and there was evidence below that at the time she was, I think, fairly heavily intoxicated, either under the influence of methamphetamine and alcohol. And so one of the issues that we've raised, and we cited to the Tucker case, I know it's an unpublished opinion, and I asked Mr. Landis if he was familiar with that case. And I cited it because it's factually, no two cases are identical, but it's pretty close to what we have here. And Tucker, in that case, said that if there's evidence of recklessness, that lesser included offenses of reckless battery and reckless ag battery are both legally and factually, or can be legally and factually appropriate in those types of cases. Again, in Tucker, similar thing. Stopped by law enforcement, drove off. The officer was injured.
But counsel, didn't Tucker really deal with the failure to give a jury instruction on a lesser included charge?
That's true.
Do you have any cases that would deal with this situation where I understand your position is a failure to discuss potentially lesser included charges being sufficient to invalidate the knowing and voluntary element of a plea?
I don't have any particular cases in Kansas that I've cited. And I agree, Tucker doesn't stand for that proposition. I think the reason that I asked Mr. Landis below about Tucker was just to see what kind of research that he had done for this particular kind of charge, and then whether he explained that if we go to trial, because of these facts, we have the potential for lesser included offenses. And so that's why I cited Tucker. Do I have a case directly saying that in Kansas? No. But I do think the ABA guidelines would, again, as I indicated, as I argued, would set the standard at least that a defense attorney should investigate the law and inform his client.
So you would agree with me that, let's put that scenario in play. He tells Ms. Heinzman, if we go to trial, there's a possibility that the judge will instruct on a lesser on reckless. But Mr. Miller, you and I know district courts do not always instruct on the lesser if they don't see that. So as an attorney, would that be wise to tell her there's lessers, but we don't know if you'll get them or not at the jury trial? I mean, it's not a guarantee that all things are going to play out, looking at it now.
I agree, and I think, but that discussion I think has to be had with your client, is that there are potential lesser included offenses that are in play here based on the facts of this case, legally and factually appropriate. We may or we may not get it, but certainly they're available, and if we go and the facts arise during the jury trial, I will request them. But at least the client should have the opportunity of weighing that in the decision of whether or not to plead guilty. And in this case, she did not have that opportunity because Mr. Landis testified below on numerous occasions that he couldn't remember if he ever discussed defenses or lesser included offenses with Ms. Heinzman, and Ms. Heinzman actually testified he did not. I mean,
Well, counsel, didn't he testify? He doesn't remember specifically, but generally, he said, my practice in general is to research the law. He said, I don't remember specifically looking at Tucker, but, I probably would have. And my practice is generally to talk about these lesser included. And he admitted he knew that she claimed that she didn't realize that she had run over the officer, or that the officer, I believe, was drugged by her vehicle. And so, does that not make a difference? I mean, we've got a little bit of equivocation at least. It's not maybe as cut and dried as I never talked to her about this, or I don't think I did, but I probably would have.
Well, again, I'm not sure that that would meet the standard of what is reasonable for an attorney. Also, I think there is case law, I'm not sure that I cited in the brief, but there is published opinions, and I'm sorry, I can't name them right off the top of my head, but which basically say a defense attorney's inability to remember whether they gave advice or whether they didn't give advice, that is not strategic, or that doesn't meet the level of reasonableness under the Strickland standard. So,
Well, if we have an attorney who, he admitted he's defended these types of cases before, specifically the ag battery charge, he's done this several times, and he talks about his general practice with how he handles those cases, why can't the judge accept that as credible testimony, at least in weighing the two versions from the client and the attorney?
well, certainly, yes, the judge can weigh the credibility. I did make an argument about the manner in which the district court weighed the credibility here. I know this court can't weigh credibility. I understand that. But I think that this court can look at how the judge below judged credibility and whether that standard was appropriate. One, he said, I believe Mr. Landis because Ms. Heinzman was using drugs. Well, there's zero evidence that Ms. Heinzman was using drugs while she was having these conversations in the jail with Mr. Landis.
Well, counsel, the judge didn't say, I didn't believe her because she was using under the influence of drugs at the time of the hearing. I mean, it's certainly possible that, you know, a past history of drug use, like she had, would affect your memory. I mean, we've got case law on that.
Right, but I think the drug issue goes to, was she under the influence at the relevant time period that we're talking about, i.e. her discussions with Mr. Landis and/or at the time of the 1507 hearing?
What's your basis for that?
I'm sorry?
What's your basis for that claim?
Well, I mean, I've cited the case, looks like I'm running out of time.
I was going to tell you, I want you to be able to answer the judge's questions, and I want our panel to be able to ask you questions. So you're not going to lose your rebuttal time, so please continue.
Okay. If I could just briefly look at the case I cited.
Is it Osby? I think you talked about Osby.
Osby, yes, sorry. So State versus Osby says, to the extent it shows the witness was under the influence of drugs at the time of the occurrences, as to which the witness testifies, or at the time of trial. I get it, at the time of the event, she was under the influence of drugs. But I think the relevant occurrences here are, one, the time that she was having these discussions with Mr. Landis, and the evidence is that she had been in drug treatment and was really starting her life over again during that time period. So there's no evidence of that, or at the trial or at the 1507, there's no evidence of that. I cited Osby for that proposition. One of the other issues that the judge used to weigh credibility was, well, Mr. Landis is an officer of the court, and he has a duty of candor to the court. I get that. That's a rule of ethics. But as far as weighing credibility, especially in the context of an ineffective assistance claim, when the attorney is essentially defending himself, it's almost like a presumption that he's telling the truth because of this rule of ethics.
But counsel, again, the judge made the comment of, yes, officers of the court, generally I can trust them, and I've also seen no evidence that he was lying, correct? I mean, the judge went on to say, nobody showed me that he's lying. It's not just I'm taking the attorney's word at face value. I'm saying maybe I start from there, but also, as with any witness, nobody's impeached their credibility. Nobody's shown me an inconsistent statement, unlike Ms. Heinzman, who'd been impeached several times. I mean, at least when you look at it in context, it seems like the judge is saying, okay, with Heinzman, her testimony has been impeached several times, when she would say, oh, they only visited me 2 or 3 times, and then the prosecutor would say, well, actually, let's look at the jail visits. And then the judge was saying, but with the attorney, we don't have any of those instances, so
Well,
I'm looking, that's how I'm comparing them, correct?
and I understand that. There were inconsistencies, though, in Mr. Landis's testimony, because initially on his initial direct examination, he denied that or couldn't remember that he even showed the injury reports and the medical reports of the deputy, and reaffirmed that on cross. And then when the importance of that sort of was coming out, then on redirect, he changed his testimony and said, oh, yes, I do remember. I went over that with her. In direct contradiction to what Ms. Heinzman said, that he basically never went over the discovery with her at all or to any great extent. So there were certainly inconsistencies in Mr. Landis's testimony. I agree. You can't judge the credibility. I just suggest that the drug issue and the duty of candor are not appropriate measures for judging credibility. I see I'm out of time.
Did
so-
you want to give us a conclusion, or is there anything you want to
Yes,
add?
for all of the reasons, and I didn't get to all of them today, but all the reasons that we set forth in our brief, we believe that Mr. Landis performed deficient performance under the Strickland standard. As far as prejudice in this context, is there a reasonable probability Ms. Heinzman would have declined to enter the plea and go to trial? She testified, had I known of these lesser includeds, had I known of various defenses, had I known of the evidence, she didn't have the discovery.
And you would agree with me, she wouldn't get the discovery because defense attorneys do not give discovery usually to their clients who are sitting in jail, because the discovery gets lost and all of a sudden you have the possibility of jailhouse informant using that discovery against them. So as a practice, most defense attorneys do not give the discovery, but what they do is they go over the discovery with them. Isn't that right?
I think, well, maybe I'm out of the realm of most defense attorneys, but we redact discovery as required by the local rules, and certainly now we can't provide the videos, of course, but discovery is given often on disc to clients in the Sedgwick County Jail. They ask for opportunity to go and look at it.
So that's
On the
that's not something that could be lost. In other words,
That's
my example was paperwork that somebody can get a hold of and used against your client.
That's correct.
These don't put your client at risk. in
That's
other words.
certainly a possibility, but I think there is a way, and there is a way.
Sure, that
That
makes
they
sense.
can view the discovery without.
Okay, good. That's good to hear, though, because you always wonder.
I'm sorry, I would ask that the court reverse the court below
Okay, thank
and
you.
allow Ms. Heinzman to withdraw her plea.
Thank you. Counsel, you have 15 minutes.
Thank you. May it please the court, Assistant District Attorney Chelsea Anderson on behalf of the state of Kansas. I want to first address some of the issues that were just discussed by Mr. Miller and the panel. We'll start in reverse order. The discovery issue, as Judge Pickering, you pointed out, it is true that a number of attorneys do not hand over copies, and pursuant to KSA 223212, she's not entitled to her own copy of discovery. The testimony at the hearing was that counsel had received and reviewed the evidence in its entirety and had discussed his evaluation of the discovery with her prior to her plea. That's all that is required. As to the credibility thing, I think Judge Klein mentioned that there were inconsistencies with her statement, and there was a claim specifically that she said he'd never gone over discovery. He visited her 8 times, and some of those were over an hour, as the inmate jail log pointed out and was gone over at the evidentiary hearing. I find it very hard to believe that none of those were discussing discovery and the facts of the case. It's the state's position that the movement has not established ineffective assistance of counsel as to the discovery or any of the claims. Moving to the possible defenses and the lessers, I would note first that as far as the defenses go, we're using that term kind of broadly here. There's been no identification of affirmative defenses that would apply. Below there was discussion of the voluntary intoxication, but that was not brought on appeal, so that was waived or abandoned. So what we're really dealing with is defense theories of the case and maybe being able to nitpick at the culpable mental state and the degree of the injury. And there's no case law that discusses that in particular, but our Supreme Court has said that it cannot be the law that failing to inform the defendant of every possible defense, no matter how specious, constitutes representation so far below the acceptable standard that it would be manifest injustice not to allow a withdrawal of the plea.
But counsel, I don't think that their argument is quite that broad, is it? I mean, they're not talking about every possible defense. They're talking about lesser included charges to these particular charges and attacking elements of these particular charges and how we would show the state can't prove their case.
Yes.
I mean, they don't have to show they didn't, it doesn't have to be an affirmative defense, first of all, correct?
I don't know.
Wouldn't you
I mean,
still, wouldn't you expect if you're gonna have a knowing plea, you would at least have some discussion about if we went to trial, here's our potential defenses to the case, which could include showing how the state can't prove their case?
Certainly, I think that would be something that would be gone over. I'm just pointing out the fact that there is case law that discusses affirmative defenses and the need to go over those. Just recently, the Grant case came down. That was an applicable statutory defense that wasn't discussed, whereas here, I guess I'm just pointing out we're using the term defenses kind of broadly. But I would
And I guess
also...
I'm trying to drill down on why does that matter?
Well, I would note that in addition to the fact that you don't have to go over every possible defense, I would note that over and over, the statement, in fact, just now, the statement was potential for lesser included, potential defenses. Well, our Supreme Court has also said that where a defendant pleads guilty, to show prejudice for a claim that an attorney failed to advise of a possible defense as well as possible lessers, two different cases, there must be some showing that the defense or the lesser would likely be applicable or would be successful at trial. And we don't have that here. We don't have that showing here.
Well, we have the Tucker case that helps with the potential for the inclusion of the lesser, correct?
Potentially, but also, as I noted in my brief, it's hard to believe that a lesser would be factually appropriate here, because at the evidentiary hearing alone, she testified, she being the defendant, movement, testified to the elements of the crime. The elements of the aggravated battery of a law enforcement officer are that she knowingly caused bodily harm, not great bodily harm, just bodily harm with a motor vehicle to a properly uniformed or identified law enforcement officer. Judge Pickering, you mentioned earlier, asked him specifically whether she knew that it was law enforcement, and she did, and she testified consistent with that at the evidentiary hearing, saying that an officer got in behind her, followed her from Derby into Wichita, turned on their lights to effectuate a stop. She does stop. Then when she's trying to be identified by the law enforcement officer, she freaks out. And she tries to get her keys back in the car, and obviously the deputy is standing right there. For knowing, it doesn't require that she's aware that an injury resulted. It's that she has to be aware that her conduct was reasonably certain to cause the result. Well, when a deputy's standing right next to your vehicle and possibly inside your window trying to fight with you over the keys, certainly if you gun it, taken off, then of course you're reasonably certain to cause some injury, and that's what we have here. So I agree with the district court's view that it's unlikely a lesser would have been factually appropriate in
But
this case.
when the district court made that statement, wasn't that statement directed to the great bodily harm issue and not the mental state? I mean, the district court didn't talk about the knowing and reckless issue. He was talking about bodily harm. Doesn't matter if it was fractured or broken, we're still hurt.
There was some of that discussion, yes, but I do recall a specific back and forth where it was noted that, yes, this only requires bodily harm. But I guess either way, I still don't think that the movement has established that a lesser would have been factually and legally appropriate. So first, I don't think he's established that counsel never went over any of this with her, but even if he had, I don't believe we've got prejudice established, and he must establish both, or she must establish both. I wanted to quickly,
So your point is, even if he had counseled her and they did go to trial and they do request the lesser, and the lesser is given to them of reckless ag battery, because she does have substantial injuries, although they label as a fracture, the jury still may convict on knowingly.
certainly. I think it's likely, considering the facts that we have in this case, as well as the culpable mental state only requiring that she be aware that her conduct was reasonably certain to cause a result. Additionally, I understand the Tucker case, but I'm a little confused because there is no reckless ag battery of a law enforcement officer. So you'd have to get all the way down to reckless battery. So that would go to whether it's great bodily harm, I suppose, but.
But what about count two? I
As
mean,
to,
my understanding is count two was, didn't require great bodily harm.
count two would have required great bodily harm. Count two was leaving the scene of a injury accident, and that did require great bodily harm. To that point, I would note, though, again, there appears to be confusion on whether a fracture and a break are the same thing, and medically they are.
Can you help me out? In volume 1 of the journal entry of her plea, the district court judge orders $33,000. It looks like Wichita, Sedgwick County Risk Management of $33,322.83. That is to take care of the injuries that was that to take care of her medical bills?
I assume so, I'm sorry.
Okay,
I
because
don't
at,
know for sure.
at the hearing, when they do order the restitution, they say she was injured, she went to the hospital. So,
She did have a surgery. I mean, that's, I guess, outside of some of the record below, so, but I
And-
believe it was in the probable cause affidavit that there was a surgery.
and so you don't know who Sedgwick County Risk Management is? That could be a surgery unit or,
I'm not 100%
Okay.
sure.
would it be false to assume that that would take care of her medical bills for the surgery?
No.
Okay.
Going back to the great bodily harm question from Judge Klein, I do want to also mention that there was a lot of emphasis on whether the culpable mental state for that could have been proved. However, leaving the scene of an accident, that statute does not prescribe a culpable mental state. So as I noted in my brief, it would have been sufficient for the state to prove recklessly, and I think that's obvious. Again, I don't think the movement has established both deficient performance and prejudice on either of those issues. Really quickly, with regard to the credibility findings, I agree with some of the statements of Judge Klein today that while the court did mention that they were officers of the court, he did also contextually say, but I've also heard nothing that makes me believe that there's been anything less than truthful, but was able to pinpoint certain things that were inconsistent and even contradictory evidence to what movement testified to. I would just quickly note, however, that if the court does have concerns with what was considered there, and I don't think, even if the judge could have possibly considered things outside the realm, he did also make findings that were appropriate, but in the event that this court decides that the credibility findings were somehow in error, I would point to the Smith case, 308 Can 778. In that case, a district court made several credibility findings based on both in-court observations and the testimony, but also appeared to improperly consider a few items. And in that case, our Supreme Court remanded the matter for new credibility findings, which would be an alternative option here. But I, again, don't think that that's necessary for multiple reasons. One, I don't think she has met her burden of establishing deficient performance and prejudice. But also, as I mentioned in my brief, I believe this court could also find the district court was right for the wrong reason. And the state is aware of the recent Supreme Court opinion regarding the cross-appeal requirement from December, and acknowledges that no cross-appeal was filed here. However, the cross-appeal requirement has not done away with this court's ability to find the district court right for the wrong reasons, especially where the question is compliance with the statute. This is best illustrated by the Ward case from 2023, where our Supreme Court indicated that it didn't matter that timeliness had not previously been raised with regard to a motion to withdraw plea, because the statute has procedural bars, and the threshold question is always whether the motion complies with the statute and its procedural requirements. The question here, all from the start, was we had a conclusory timely motion. So, but this court in the Booker case, since this case was decided, the Booker case came out and clearly indicates that you can't file a conclusory motion and try to later attach or toll the time period in order to try to improve upon that conclusory filing. In addition, the main cross-appeal case, the Cook v. Gillespie case, also notes that an appellee may brief matters for affirming the district court if those matters were raised below but unaddressed by the district court. And I would note that the district court never addressed whether the motion, the initial timely motion, was conclusory. So I believe that this court can find that the timely pro se motion failed to comply with the statute because it was conclusory, and that all subsequent filings were untimely with no manifest injustice established and no anchors to relate back to, and still affirm for different reasons if the court disagrees with the state that movement hasn't met her burden. Either way, the state asks that this court affirm the district court below, and I am out of time. So unless there are further questions, thank you for your time.
Thank you. All right, counsel, as we get that clock set for you, you have 5 minutes.
Thank you, Your Honor. I wanted to start maybe right there where we left off. In my reply brief, I cited the Lumry case for the proposition that right for the wrong reason is for those issues that were never addressed by the district court. Here, the state filed a memorandum or a motion to reconsider the judge's ruling, finding that we should have an evidentiary hearing, that the subsequent 1507 that I filed related back under the relation back rule, and the state did not appeal that decision. He denied their motion to reconsider. So the issue was raised below. The judge denied it. They didn't file a cross appeal, and the right for the wrong reason rationale does not allow this court to find this alternative basis to affirm the trial court. Just on the, and there were questions or the argument was made that there has to be some showing that a lesser included offense, for instance, on the ag battery, would have been successful. And I guess in this context, successful, I'm not exactly sure what that means, other than that there's certainly a possibility, and I'm basing this on Tucker and McCoy, neither of which Mr. Landis could remember, whether he even remembered those or even discussed them with Ms. Heinzman. Both of those, McCoy, the jury actually convicted on the misdemeanor reckless battery. And Tucker certainly stands for the proposition that under the facts of that particular case, they reversed and said these are legally and factually appropriate. And the facts in Tucker are remarkably close to this case. The officer in Tucker had a fractured wrist. Her wrist was, she had a cast on it, I think, for 5 to 6 weeks. She had to go to physical therapy. But even so, even on the issue of great bodily harm, which I know goes to count 2 here, the Tucker court said that's a question of fact for the jury. A judge can't make that call. So I think Tucker, the holding in Tucker, the holding in McCoy, certainly stand for the proposition that there's certainly a reasonable possibility or probability that those lessers could have been given under the facts of this particular case. One thing I did want to discuss was the error in sentencing here, or the misadvice about sentencing. In this case, again, there was a misadvisement as to what her proper criminal history was going to be. That was in the plea agreement. I think said F. Ultimately, it was E. But I think at a more fundamental level, Mr. Landis testified that she could receive a concurrent sentence.
Could and almost certainly would, I believe was his testimony, is what he told her, correct?
He did. He did say
Could and
that.
almost certainly would run consecutive.
That's
Why
correct.
is that not an accurate representation of the situation
Because-
that she faced? Because almost certainly would, yes, we've got this rule, but if we show manifest injustice, then it wouldn't apply.
Right, but this court in Wilkerson said the manifest injustice finding is almost insurmountable. And the acknowledgement form, which the state's attorney went over with Ms. Heinzman when she was on the stand, it says you could receive concurrent sentences and you could receive consecutive sentences. But we all know, based on that manifest injustice standard, it was essentially an impossibility that she was going to get 92 months.
So then why doesn't the phrasing almost certainly would equate to the situation she was facing?
Well, I think that's what he thought that the court would end up at. He also told her, the state's going to ask for this, we're going to ask for this, and the judge will go somewhere in between. Well, that's not accurate either. The judge, again, based on the manifest injustice, or I'm
That's what
sorry,
your
based on the
client
mandatory.
testified.
I'm sorry,
That's what your client testified she was told,
correct.
that there would be some midline.
That's correct. She did. Again, I'm running, I know, short on time, but I would just ask again for all the reasons we stated here and in our brief that this court would find both deficient performance and prejudice. I know there was an issue about prejudice, and Ms. Heinzman was very clear on several occasions that had she known about the lessers, had she known about all of what we would have went over, she would have insisted on going to trial. She also said, I didn't want to sign that plea, and Mr. Landis agreed. When the state recalled him, he said yes. She said, I don't want to sign it. So there certainly was agreement there.
And she's aware that there's this serious and strong media coverage of this case. She would still want to go to trial. And she would,
I mean, that was her
I mean,
testimony.
that's the part that I don't think has been identified here. So this was a very high-profile media case. And so she would still want to go to trial with all that publicity that she had run over a police officer.
That was her testimony, and again, I mean, we didn't get into, you know, there's certainly avenues available. If the prejudice in the community is enough, you could do a motion for venue or change of venue or what have you. But that was her testimony. I mean, had she known the evidence and the officer's injury, I'm not diminishing that in any way, but her surgery was elective. There was no, I mean, that record below is clear. That was an elective surgery. It was not something that she had necessarily had to do. It was an elective surgery. But had she known all that, all the evidence, yes, she testified absolutely that she would have gone to trial. And we believe that meets the prejudice prong. We'd ask for the district court below to be reversed.
Thank you. We appreciate parties' argument, and we will see. Take this matter under advisement. With that, we will then call our second case. State of Kansas versus Sidney Clark. Ms. Miller, you may begin.
Did you want appearances?
Yes, at the podium.
May it please the court, Mr. Clark is in custody and appears by counsel Wendy Miller.
You could enter your appearance when you go to the podium.
Well, we're here from another appeal.
Oh, I'm going to stop you. Rebuttal time, Ms. Miller?
Yes, please, 2 minutes.
2 minutes, thank you.
So this is an appeal from the second resentencing for Mr. Clark. One of the issues that he raises in his brief is that he had filed a motion prior to resentencing back in 2022, which was the most recent resentencing, challenging his prior convictions. And he made a general challenge to his convictions. And then he also indicated that some of the convictions may be uncounseled, and asked basically that for the state to hold their burden and prove his prior convictions, noting that there was no documentation to support the convictions included with the PSI, such as journal entries or other documentation to support the convictions.
Now, counsel, am I correct that by the time this motion was filed, your client had already admitted the accuracy of the PSI twice?
In his prior proceedings, he did, but because this was resentencing, then, and he can't agree to an illegal sentence, he could come back and challenge his criminal history since he was being resentenced. So with his written objection to the criminal history.
Can I stop you there? I'm
Yes.
intrigued by a phrase you used. You said he made a general challenge to his convictions. What do you mean by general challenge? I'm not used to that. If I was a district court judge and someone says I'm generally challenging my criminal history, can you explain what that means in order for the...
My understanding is that he was challenging all of his convictions that were listed in the PSI.
Under what basis?
Well, he indicated that some of them may be uncounseled and asked for the court to hold the state to their burden to prove those convictions. And the other basis would be because he didn't believe they were supported with any kind of documentation, such as journal entries or other kind of documentation.
Now, counsel, normally when we have challenges to a criminal history, we've got a burden shifting framework, correct?
Yes.
Where, depending on where we are in the stage of the proceedings, that, and when the challenge is raised, that really dictates who has the burden. So here we've got a situation where your client admitted twice to the accuracy of the PSI, and then several years later is trying to shift the burden onto the state. Why shouldn't we take that into account and say, at this point in the proceedings, after you've already admitted it twice, and all this time has gone past, that you, clerk, have the burden to show that the PSI is inaccurate, and have a very specific challenge, like maybe point out which conviction wasn't counseled, or give some specifics, or, provide the documentation to show that a conviction was misclassified. Why should we, at that late stage, under those circumstances, then force the state to prove and bring the documents for all of those convictions?
I'm not sure that it necessarily matters that he didn't challenge it previously or previously on appeal, because once the court remanded for resentencing, and vacated his sentence, he had to be sentenced anew. So in doing that, the district court would have to consider his criminal history.
But wasn't the remand a little more limited? I mean, didn't the remand basically say go back to that first sentence?
It did say to go back to the first sentence, but in doing that, I think that as part of resentencing him, that the criminal history can't be ignored. So if he makes the written objection, the state then has the burden to prove the criminal history.
And I'm not suggesting it should be ignored. I'm just talking about the burden shifting. Why isn't it Clark's responsibility to prove the inaccuracy at that point?
So we cited a case in our brief that the state can't rely on a PSI when an objection has been filed. That places the burden on the state to provide further evidence. And I think that was the Show opinion, 287 Kansas 529.
Is that a similar context that we have here? I mean, doesn't that case talk about the initial challenge? I mean, like the first time it comes up?
Right, and this is not the first time he's been sentenced, but this is sentencing anew. So it's a full resentencing. He's not just coming down for, for example, to correct a post-release provision, or maybe the case where the judge misstates that someone should be on lifetime post-release instead of stating parole, and it's just correcting that part of the sentence. In this case, the sentence was vacated and remanded for resentencing, and it was consistent with their opinion, because the continuing challenge has always been whether to apply Wetrick or not, and the developments that have come into play since Wetrick. So, but I think once the sentence has been vacated and remanded, then sentencing anew has to take place, and in doing so, if he files a written objection to that criminal history, pursuant to, or in this resentencing, then that shifts the burden to the state to respond to it, even if he didn't do it previously, because this is sentencing anew.
You said pursuant to, were you about to give us a statute?
I did cite a statute, 216813B5, which requires the source of information behind the conviction. So there's got to be journal entries or other documents. Mr. Clark's opinion argument is that because the PSI lacks information about how those convictions were verified, and it doesn't contain any journal entries, that was his objection to including the priors, and so that he should be resentenced at an I. And then, as we've indicated in our reply brief, if if we look at Dickey, which said that a stipulation or lack of objection regarding how convictions should be classified or counted as a matter of law for the purpose of determining criminal history, that will not prevent a subsequent challenge under the illegal sentence statute 223504. In this case, we're not dealing with a motion to correct an illegal sentence, we're dealing with a motion, or with resentencing, and so
Wait,
it's our
aren't you
position.
dealing with the motion to correct a legal sentence? It
Well,
was
that's
his.
that's how it started, but the remedy for, or I guess the finding of the court was that the sentence in 2019 was illegal, and so that sentence was, on appeal, was vacated and remanded for sentencing anew. So our position is that the court cannot sentence him without considering that criminal history. And even if he didn't raise it in a previous sentencing, because it's sentencing anew, if he files the written objection, then the state has got the burden to prove that conviction.
I'm going to quote you the last sentence of that State v. Clark, and I'm going to get very detailed, so bear with me. Based on the foregoing analysis, we affirm the judgment of the Court of Appeals, reverse the judgment of the District Court, vacate Clark's 2019 sentence, and remand for resentencing consistent with this opinion. All right, so consistent with this opinion, does that tell the District Court sentence him as a criminal history score B? Because consistent with this opinion means something. It has to mean something.
I think the court, in carrying out his duties and sentencing him consistent with the opinion that if something arises, that the district court has to address in order to proceed with the mandate and what the mandate's directing him to do, that can be taken up and should be taken up. So I don't think it would be inconsistent with the opinion if he had additional written objections concerning the convictions to take that matter up, if that answers the question.
What did you mean by that?
So he was to be resentenced consistent with the opinion, and so the opinion was dealing with the Wettrick objection, or the Wettrick line of cases, and how the history should be scored, whether the Oklahoma conviction
Right.
should be scored as a person felony. But once the sentence is vacated and remanded for full resentencing, I think the additional written objection by Mr. Clark can and should be taken up by the court in in executing his duties to follow the court's mandate.
Okay.
And I believe, I base that off of the decision in Soto, where if a new matter arises, new situations that the court needs to take up in following the mandate, such as somewhat similar as the facts in Soto, where there was new factual evidence that was presented in a motion for a new trial. And so the question was, could that be taken up? Would that be consistent with the mandate? And the court found that in executing his duties, that was something that the court could take up.
Do we have that same situation here?
I think that we do, in the sense that in resentencing Mr. Clark, that the court can't ignore the written objection. Once that's filed, this state has the burden to produce the evidence, and I don't think it's inconsistent with sentencing him in accord with the opinion. Now, there's nothing that's going to change about the Oklahoma conviction in that, what they found about the elements. Okay, whether Wettrick applies or Vandervoort applies, that's been decided. And that's part of the mandate to resentence him, is here's our decision, that was illegal in 2019. Now we go back for resentencing. But if he's got new written objections, I think the district court has to answer that.
Well, Soto, was it new written objections, or it was new information that came to light?
His was new factual evidence, and so he had filed a motion for a new trial, and he was there for resentencing, And then there was a question with whether the motion for a new trial could be considered if it was outside of the mandate. So, but here I don't think it is. I think it is something that the district court needs to do if there's a written objection for any reason, because it is sentencing anew. So a criminal history is, the court has to decide that in sentencing him. And that's not inconsistent with what the court's decision was regarding the Wettrick argument.
If a defendant makes a objection to their criminal history prior to sentence, must the district court always take it up?
I think it shifts the burden to
I mean,
this.
can't they look at the basis, I mean, can't they see if it's merit, if it's full of merit, if it's merit or has no merit to the arguments presented? Because from your argument, a district court would always have to take up a defendant's challenge to their criminal history.
I think if there's a written objection, then it's up to the state to prove the criminal history. And I can see I'm out of time.
Did you want to summarize your argument, or if you have wanted to?
Well, I didn't
If
get
you
very
don't want
far
to,
down
I'm
the
just
line
giving
with-
you, I'm just giving
with
you that
the-
out.
With the issues, but it's our position, at least on the criminal history, that the state didn't meet their burden, that the criminal history arguments should have been considered by the court, and that without having proof of the convictions being counseled, his case should be remanded and he should be resentenced with a criminal history score of I.
Thank you, Ms. Miller.
Thank you.
Go ahead and begin, Your Honor.
Yes?
Good
And-
morning, Your Honors. May it please the court, my name is Bach Hang. I'm an assistant district attorney with the Reno County District Attorney's Office on behalf of the Appalachian State of Kansas. Your Honors, I wanted to open up my oral argument by saying that this was not we're here now not because a panel of Your Honors on the Court of Appeals made a decision that the appellant, Mr. Clark, is trying to undo or overturn. It was the highest court here in our state, Kansas Supreme Court. The state's position is that the Kansas Supreme Court got it right. Their opinion is correct. Even after all of the back and forth arguments, even after twice Mr. Clark's journey to the Court of Appeals and then back to the district court and then back again, even through all that, as of today, as we sit here today, as we stand here today, there are principles about this issue that are tried and true. And make no mistake, this is about an illegal sentence or an illegal sentence claim by Mr. Clark. It drives the appellate issues in this case. 223504 is the statute that we're talking about. So those principles are that the law at the time of the sentence controls, the lens for what the court should have looked through in 2005, that lens was the comparable felony lens for the out-of-state conviction from Oklahoma. Placing bodily fluids was the name of the statute from Oklahoma. It is comparable to battery on a law enforcement officer. The Kansas Supreme Court's ruling is consistent also with its own rulings in Murdoch and in Wettrick. And I don't know if Your Honors have taken a look at the legislative history of 223504. Truth be told, I kind of geek out about legislative history. I love looking at session laws. I think it started right after I entered into private practice. But if you look at 223504, kind of surprised me, but only twice has the legislature changed that statute. And by change, I mean either added to it or amended it. On June 22nd, 2017, 223504, and that's the statute about correcting a legal sentence. It defined what an illegal sentence was, very narrowly defined. Constitutional challenges cannot be made. And then again, on May 23rd, 2019, the state legislature changed or amended 223504, and I think that was in response, a second here, that was in response to what the Kansas Supreme Court said in Murdoch. And that change basically was, it defined what change in the law was.
And Counsel, is it Haig?
Hang, yes.
Haig, Mr. Haig, Ms. Miller's not disagreeing with you. Her argument is, he came back, he was supposed to be resentenced, at his sentencing, he moved to have the state prove his convictions add up to a criminal history score B. So what is your response to that? If I
Your
may
Honor, my
move you
response-
off
I'm
your legislative history review.
Your Honor, my response to that is, well, first of all, I don't know what appellant's counsel means by sentencing anew. I would echo and reiterate, Judge Pickering, your question and your, I don't know if you intended to, with your question, to say this, but the Supreme Court of Kansas said, we're sending it back to be resentenced consistent with this opinion. And as your honors know from your collective experience, when an appellate court, be it a panel of a court of appeals, be it the Supreme Court of Kansas, says, well, we're remanding this back to you, and says consistent with this opinion, it's not sentencing anew. I know we're lawyers and we're always tasked to ask that question, what does that mean? What does that mean? Sentencing anew cannot mean what was briefed in the appellant's brief. It cannot mean, let's start over. It cannot mean, let's relitigate this case. It cannot mean, let's relitigate issues. There's got to be some finality here. And I think the Supreme Court of Kansas certainly could have written, let's remand for sentencing, and then stop talking and writing. It did not do that. The Supreme Court of Kansas, like it always does, is at least to me, it's pretty clear on the instructions on what the remand is, consistent with this opinion. Consistent with this opinion means district court, do whatever you want to do, give Mr. Clark his sentencing again, but it's got to be consistent with our opinion. And our opinion, Supreme Court said, was his criminal history is B as in boy, and that his sentence should be 460 months.
So, just to put this in framework, this is a motion to correct a legal sentence based on one thing. The one thing is that he challenged his Oklahoma felony and said it should have been a non-person versus person. That's the only argument he raised in motion to correct a legal sentence, correct?
Your Honor, that is the state's position.
Right. So based on that, should he be allowed to go back and be sentenced and being able to raise everything when he's only challenged that one aspect of his criminal history in his motion to correct a legal sentence?
Absolutely not, Your Honor, because if Mr. Clark is allowed to challenge, thing 2, 3, 4 again, then he's going to want to challenge thing 57, thing 65, and come up with other things. Example, Your Honor, an example of that, I'm not just making that up. An example of that is in the appellant's brief, stuff about there was a delay in the mandate, there's mootness here going on, there's a double jeopardy claim. Your Honors, all that is centered around one thing. I don't like my sentence was illegal. Unfortunately for Mr. Clark, the Supreme Court of Kansas has spoken already. And if you look at the Supreme Court's opinion in Clark, it wasn't just like, hey, let's write 3 pages and then affirm. it was a very, very well thought out written opinion. It started with, for I think 7, 8 pages. The Supreme Court dissects, are we even allowed to hear this? Do we even have jurisdiction? Yes, we do. Supreme Court even took, the Supreme Court even criticized the state for not doing what it, for not filing a petition to the Supreme Court earlier. So it was critical of the state. It was critical of Mr. Clark, and I think that what the Supreme Court did with that opinion was, it said that, look, here's what Wetridge says, here's what Murdoch says, and here's what the law of the land is. And Your Honors, it wasn't everything that was analyzed by the Supreme Court in its opinion was consistent with what the statute says. I want Your Honors to also, I want to point out to Your Honors that the appellant's counsel did not mention it in her oral argument, but as Your Honors know, there was, I believe, an addendum that was filed by the appellant. There was a Kansas Supreme Court opinion. I think it's unpublished. Well, I'm sorry, it's not unpublished. There's just no citation yet. State of Kansas versus McCrae. It sounds like, when you read that opinion, it sounds like the appellant is saying, hold up. Is the Supreme Court saying something different than what it said when it ruled against Mr. Clark? Your Honors, I would ask that you not fall for that. I think the Supreme Court in McCrae said the same things that it said when it ruled against Mr. Clark. Nothing in McCrae helps Mr. Clark. The principles that the Supreme Court talks about in McCrae are still true, still law. The law at the time of sentence controls. The lens to look through for Mr. Clark is, was that out-of-state conviction comparable to a felony here in Kansas? And if you think about it, Your Honors, Mr. Clark waits 12 years, right? He waits 12 years to file a motion to correct legal sentence. And I think one way to look at that is, he wasn't even talking about his sentence being legal.
Well, in his defense, Murdoch doesn't come out
And-
for many years.
And Judge Pickering,
I mean, because he's sentenced in '05, and none of this starts playing for another 10 years.
Judge Pickering, I'm glad you brought that up. I think that lots of prosecutors would look at that and say, come on, judges, he waited 12 years. Why did he wait so long? Here is the state's position here in this case. It wouldn't have mattered how long he waited. I mean, think about it. It wouldn't have mattered. If Mr. Clark, the opinion in McCrae, on the premise that McCrae, that the appellant is saying, hold up, McCrae is saying something different. Kansas Supreme Court, you're saying something different than what you said in Clark with McCrae. On that premise, here's the state's response to that. Because McCrae was decided, it looks like, December 25th. I think it was December of 2025, so like a month and a half ago. The state's position on that is, let's get into a time machine. Let's travel back in time. And let's have Mr. Clark make his initial motion to correct legal sentence. Because as Your Honors know, you can correct a legal sentence. A judge can certainly take it up at any time. Let's say he did it on January the 3rd of 2026, or he did it like yesterday. The state's position is it wouldn't have mattered. He certainly did not know about Murdoch and Wetridge, but we have the case law we have now. And so now what the state is saying is, now the Kansas Supreme Court's ruling that it made in Clark, saying that your criminal history is B as in boy, your out-of-state conviction in Oklahoma is a personal felony, it remains intact even through all the Wetridge stuff, even through all the Murdoch stuff, even through Clark 1, Clark 2, even through all the analysis, even through all the changes by the legislature. It makes sense. Plus, the opinion makes sense, does it not, Your Honors? I mean, sometimes
Well,
logic.
the court is really basically saying it should be a B in light of in Clark, the Supreme Court is recognizing case law's changed, and now it reverts back to a B, right?
Correct. Correct. And I would close my remarks with saying, you know, sometimes logic and law don't always coexist. Sometimes I think legislators, judges, prosecutors, defense lawyers, we say things, we write things that, you know, there's probably a legal principle that upholds it, but it doesn't make much sense. Your Honors, here in this case, the Supreme Court of Kansas made sense when they said, you know, when you get sentenced, at the time you get sentenced, that law should control. And that's the state's position. And thank you for the time, Your Honors.
Thank you.
If you have any more questions, I'm happy to answer.
No. All right, thank you. Ms. Miller, you have your rebuttal time?
Yes, just briefly.
Can you just give us a second? We're fixing the clock to get
Sure.
you, so I can take a breather. All right, you may proceed, Ms. Miller.
I just wanted to, the court had asked if there was a statute under which Mr. Clark was requesting his criminal history. And so in our brief, we had cited 21-6814 C, and also 6814A. And in talking about, can the district court do anything else other than what the mandate is stating? As you're aware, Mr. Clark's counsel filed a motion for departure, and he had requested discovery. He had secured approval for an expert, so he wanted discovery for the expert to see, because he didn't know, you know, everything in the case. He was just getting acclimated with it, so he asked for a continuance, which was denied. He filed a basic departure motion that did have some good departure reasons in it. But our position is, in Dixon, in the case we cited in our brief, there was a question whether the court could take up the motion for departure at resentencing. And the court found that when an appellate court vacates a sentence, the mandate requires the court to sentence anew. So the defendant is in the same position as he was in the original sentence. So our position is, yes, he can file that motion for departure. And we believe that the district court should have granted that continuance so that defense counsel could have presented mitigating evidence on behalf of Mr. Clark in support of the motion for departure. And there are instances where that yes, you can, and that does not negate or somehow not follow the mandate. And I can see that I'm out of time, so unless there's any questions.
I really appreciate both parties' arguments. You may sit down. Thank you.
Thank you.
All right, we will take that matter under advisement. We will take a short recess and be back at 10:30.
All rise.
Thank you. You may be seated. Wait just a moment. All right, at this time, this court calls the last case on the docket, State of Kansas versus Eric Miguel Camacho Rodriguez, case number 126826. And parties, you do not need to make your appearance until you come to the podium.
Good morning. May it please the court, Carol Longenecker-Schmidt on behalf of the appellant, Eric Camacho Rodriguez. Judge Pickering, if I may, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Today, Your Honors, my intent was to address mostly the second issue in the brief, the Batson issue, and submit issues 1 and 3 on the brief, unless Your Honors obviously have other questions. But that seems to be the issue where there's the most kind of up for debate, I suppose. My understanding is that the state is conceding that the district court erred when it determined that the Batson challenge to the alternate juror in question here was not ripe. I think the state is arguing and agreeing that the district court should have addressed that issue right then and there and not waited to see if an alternate ended up serving. So I think we're in agreement on that. I think where we diverge is that the state is arguing that that error was harmless for a couple of reasons. And the way I'm separating it out is sort of a big picture and then sort of factually specific to this question, to this case. Big picture, our argument is that Batson violations are about more than the jury verdict. They're about more than actually who ends up specifically serving on the jury. They are a structural error. I think the state is saying that because no alternates served, the alternates weren't even really part of the structure or part of the process necessarily, so we don't even need to get to that question. And my argument is that that's not true. So once ER was struck, that's when the harm occurred. Part of the Batson analysis, specifically in the third prong, is not just looking at the specific challenged juror, but also looking back at previous strikes. And in this case, defense counsel said, well, this is the third Hispanic potential juror that the state struck. So it's not just about that specific juror that was struck. It's also a more comprehensive look at how the prosecutor exercised peremptory strikes throughout all of voir dire. And so if the district court judge had addressed the third prong, he would have been looking at the specific characteristics of ER, the demeanor, and the responses that ER gave to questions, but also looking back at these other previous strikes that the prosecutor had made. So there's a potential here that even though we're focusing in on ER here, we're actually looking at the whole process of voir dire. If there's a determination that the prosecutor was using discriminatory intent in striking ER, that could also extend to the previous ones too. I think that's what the defense counsel was saying. They look at all the circumstances of the voir dire. And so then if that's the truth, or that's what happened, and we don't know because the district court judge didn't make that final ruling, but if that's what happened, it's really irrelevant that the specific challenge juror was an alternate, because you're having a prosecutor exercising strikes when they were exercising strikes on the general panel too, not just the alternate panel, if that makes sense. Alternates are sworn in, they're part of the process. It also matters what the litigants, the people in the gallery are thinking when they're watching a trial happen. They don't necessarily know who is an alternate and who is a main juror. They're just gonna see, a bunch of white people. And so our argument is it's about more than just specifically the verdict and just specifically who served on that final panel, that the harm extends beyond, beyond that specific alternate. I think the state is also saying that if, the error here is harmless because even if the district court had made that final third ruling, ruled in the third Batson step, it would have concluded that there was not enough there, that defense counsel hadn't presented enough. And the state can obviously correct me if I'm misunderstanding this. Our argument would be that's for the district court judge to determine if there's enough. Body language was one of the main issues here, and all that, though that can be one of the race-neutral reasons for step 2, we're at step 3 now, and the district court judge needs to look, okay, do I believe that? Is that plausible in light of all of the factors going on here? We don't know what that body language was other than a chip on the shoulder. All body language is not equal, is what I'm saying. And the only person who can really evaluate the plausibility of the prosecutor's, reliance on body language is the district court judge, the people in the room there, and not any of us.
So then whose responsibility is it to ensure we have those findings that are made? I mean, we can't make them now. And so what do we do when we don't have a record of those kind of contemporaneous evaluation of the arguments and the factors?
My argument is that this court should remand for a proper Batson hearing, and I do understand the procedure's kind of awkward there to go back and do that. But there are cases of this court, of Kansas appellate courts doing that. And I think it's the Bolton case that toward the end has a description of what that remand hearing should look like. And it's, send it back for, you can re-argue the same things. You can look at the record, like what we have. I don't think you can present new evidence. But the important part is, even though we're way after the fact, and this is not ideal, the important part is you at least have the people who were there in the first place to make those factual findings. It's not great.
And how practical is that, really?
I don't know. It probably depends on a lot of factors. I don't know here if there was a live transcriptionist or if there's a recording. If there's a recording, you can hear voice, tones and get a little bit of a different sense of what's going on. This was COVID times, and I don't recall if there was any Zoom. It's not very practical, but it's the best thing we have, I think. My argument is that it can't be true that all Batson violations involving alternate jurors are harmless if no alternates serve. Because you could run into a situation where a prosecutor makes an inappropriate strike and says something awful on the record, like blatantly racist, and for some reason maybe the judge, doesn't pick up on it. And so you have this glaring, blatant racist Batson issue here, but it's harmless because I think the state would say it's harmless if an alternate doesn't serve.
But that's separate from the preservation issue. I mean, we're kind of back to the structural error, but my concern is kind of this preservation issue and our lack of findings to really analyze it, and just kind of the impracticality of sending it back now and trying to have the district court recreate something. I mean, my concern is we're rewarding a defendant for not making a record below and still allowing it to go back for some recreation.
Sure.
And what's the effect of that ultimately going to be?
Sure. I mean, some courts honestly place the responsibility in defense counsel, right, to object, and object again. And defense counsel did not object, 6 times, but defense counsel raised it. And my argument would be that the district court judge just said, well, we don't need to consider it. You're preserved for appeal. I think the judge said that twice. You're preserved for, I apologize. You're preserved for appeal. We don't need to reach it yet because it's ripe or it's not ripe. You're preserved for appeal. My sense is if the defense counsel had said, well, hold on, I want you to make factual findings. The judge had already concluded it's not ripe. I don't need to make findings. So I'm not sure that an additional objection would have gotten that. I agree it's awkward, and
Can I ask you your understanding of how the voir dire process was done, the difference between the 12 and then the alternates, because that was two separate steps, right?
Right. And I don't see it done like that everywhere. Often you just, make your strikes and then draw for alternates. So it seemed,
Right.
I think they each had 12, I think they each had 12 and went through it. And then they said, okay, now you each get to make 2, and those are going to be the alternates.
In a pool, it's something about a pool of
Right.
6 alternates, then you each get a strike,
Right.
at least one, I think. So it was a separate, which is interesting to
It
me.
was interesting. And the charts where they make their strikes are on, they start on page 94 of volume 1, and they're kind of hard to understand because there's some things that are crossed out and some arrows. But I think that by the time they had each made their 12, they were down to 6, I think, and then they made 2 each.
Well, why that's important to me, obviously, is your argument earlier about was the original 12 tainted in some way potentially? And I'm saying I'm interested in how the alternates were done completely separately after the initial 12 were selected.
Right. I think they were all done at the same general time. And I think that the few times that appellate courts have addressed this question about, alternates, when you look at discriminatory intent, I think you look beyond the alternate pool. You would go ahead and look back at the general pool too. So I think it's kind of a false distinction, even though they drew that line. It was odd. I'm not sure if I have any more helpful things to say on that.
You have about 1 minute left. Did you wish to conclude, or?
My conclusion is just to request that this court remand for a proper Batson hearing. The district court's the right court to make those factual findings, and we might end up back here, but it's the best solution we have.
Thank you, counsel. Appreciate it. Right, you will have your rebuttal time. Mr. Maloney, you'll have 15 minutes.
May it please the court and counsel. Assistant District Attorney Matt Maloney for the state. I'll also focus on issue 2 here today. I think Your Honors pointed out correctly that there's really, 2 separate things as part of defendant's argument. One would be this issue of whose burden was it below when it got to that 3rd step. And we do acknowledge that the first 2 steps really aren't an issue here. And the court, so it does get down to that 3rd step. And at that 3rd step, this court reviews for an abuse of discretion and gives significant deference to the trial court. And I would start off by acknowledging that counsel's correct. We acknowledge that I think it would have been appropriate for the district court to rule on the issue at that time, that this was not something that was not right. Because I think just logically speaking, if you don't rule on it at the time that counsel raised the argument below and you wait until the end of the process, then obviously you've already gone through the trial. You really can't go back to the beginning. And so we do think that it was raised at the appropriate time below. But our issue is that after the state had provided its race-neutral reasons, the district court gave the defense attorney a chance to address those reasons. And counsel didn't really do anything about the reasons that the state had articulated, didn't challenge those. I think all counsel really did at that point was to just point to the fact that, well, the state had already had already used a strike against somebody, another person who was Hispanic, but they did not address the reasons that the state gave for striking ER, which was body language and some specific concerning answers that that ER had given. So because the defendant did not address those, that's why the court was not even, it's not a matter of the court not having given the defendant the chance. The defendant was given that opportunity and didn't try to do so at that point. And so that's why, to the extent that the record is lacking, that's the defendant's burden, and it's not something that needs to be remanded when the defendant himself is to blame for the lack of specific rulings on those reasons that the state articulated.
So how does that work then? The state presents their race-neutral reasons, and then you look to the district court, or you look to the defense attorney to counter that?
Well, I think I cited Brown, which was a case where our Supreme Court said that essentially at that third step, the burden is on the defendant. And so in the Brown case, I think what happened is that when it got up on appeal, the defendant was trying to challenge that third step, but he was raising issues or specific arguments that he had not raised below. And they said, no, we're not going to, it's not the district court's job to sua sponte address reasons that the defendant failed to argue below. And so I do think that it's on the defendant at this point, and it was on the defendant below. And so I don't think, to counsel's point, that this case should be remanded for exploration of those issues. I would disagree, because I think he did have the opportunity. If our facts were different, let's say the district court had prevented defense counsel for whatever reason from responding to the race-neutral reasons that the state gave, then I would probably agree that in that situation, some sort of remand would be appropriate if the defendant was not given the opportunity when he tried to do so. But when he was given the opportunity and he simply chose not to do anything about that, then I think there's no need for a remand, because again, it's not the district court's job, and it's certainly not this court's job as an appellate court to sua sponte address those issues. So then that leads us to the structural error argument that the defendant has made. And I cited in the brief multiple cases, but I think the Dixon case, the Nevada Supreme Court case, is the one that really summarized and synthesized all those cases.
Can I interrupt you? I just want to make it clear. So you're not conceding any error at all in the Batson analysis, correct?
I think...
I want to clarify that.
Sure, no, exactly. Yeah, I think that the error would be to the extent that the court said that he didn't think that it was ripe, then I do think that's a mistake. But I think that because before that, the court had already gone through basically the process of, okay, the defense raised the challenge, now I'm going to have the state give their race-neutral reasons, then I'm going to give defense counsel a chance to respond. So really, they went through the three steps. So that was not an error. I think the error was then basically after that saying, well, you know what, because it's an alternate, I don't know that we need I don't need to actually rule on it right now, and it only becomes ripe if one of the alternates serves. So I think it went through all the right paces. It just failed to then go ahead and make the ultimate ruling.
Okay, thank you.
But returning to the structural error, I think the Dixon case does a good job of explaining why this is not structural when it is an alternate or a potential alternate. The language about structural error, and this court's well aware that there are very few errors that are structural in nature. And essentially the case law talks about it has to be something that affects the entire trial process. And here, it's structural because there's essentially no way to determine whether the error was harmless or harmful. But here, we can know beyond any shadow of a doubt that it had absolutely no impact on the trial process.
But counsel, it's my understanding that when we're looking at structural error, it's a little more foundational. I mean, your friend on the other side is mentioning it goes to just the inherent wrongness, for lack of a better term, of the behavior, the perception of fairness when you've got the defendant sitting there looking at a jury that maybe doesn't reflect what they think a fair jury pool should be. So if we're looking at it from that kind of broader sense and more foundational aspect, does it really matter if the alternate participated?
And I appreciate that question. I think in this case, our facts, and to your Honor's point about the way that this was done in this particular case, is that it was separate from the selection of the 12 jurors that ultimately were impaneled. They had already finished the entire jury selection process. The parties had both used all of their strikes, and it's noteworthy that the defendant never raised a batching challenge to any of the jurors that were in that the group that actually served. And so I think part of the argument that the defense is making today is that, well, it could nevertheless have affected things because maybe it bled over. Maybe there was something in the jury that ultimately did sit that was, related to whatever reason. But I would argue that if that were the case, obviously the defense had every opportunity to argue that the state was using improper bases for challenging or removing jurors from the panel of 12 that actually sat. So I think in this case, just especially due to, and I would agree, I think this is a fairly unusual way. Obviously, I don't do trial work, but in the transcripts that I review, I haven't seen a lot of judges do it this particular way, where you know up front that you're separating out the panel from the alternates. But because you already went through the whole process with the panel and the defense never raised a Batson challenge, I think it's pretty telling that the defense itself did not see any issues with the jury that was selected. And so that's why I think it further supports an argument that there is no concern that this was something that affected the trial process at all. And I think at the conclusion of my brief, one of the
But again, you're still talking about the deliberation process ultimately, because you're focusing on those 12 jurors. And it's my understanding that in addition to that argument, your friend on the other side is talking about just the perception of fairness and the inherent, problem with this at all, and how it kind of infects the whole process, the perception of the defendant, and maybe even the perception of the other jurors who are participating and seeing how this happens.
Right, and
how do we address, if it's that fundamental?
I guess I would again respond that if there truly were that fundamental a failure, that it would have been raised by counsel at the point where defense counsel had the opportunity to challenge the makeup of the initial jury. And especially given the fact that we know that this defense attorney was not reluctant to raise a Batson challenge if they felt it was warranted, because they did just that to the alternate. So I think you'd have to somewhat turn a blind eye to what actually happened in this case. And that's why I think, again, the Dixon court talks about the fact that when you're looking at structural error, it's oftentimes because you really can't determine whether there was or was not prejudice based on an error that happened. But here, and I think it's noteworthy that really in my research, and I think the Dixon court does a good job summarizing it, I think the vast majority of state and circuit courts that have addressed this have come down on the side of it is subject to harmless error analysis. I think there was really just one state or one outlier court that I found and that I cited in the brief that did hold that it was structural, but that was very much in the minority. And I think some of the courts, and I understand counsel's argument today, and she said, look, it shouldn't be, the rule shouldn't be that it's automatically deemed harmless just because it was an alternate. I don't know that that this court would need to answer that question, because I think you certainly could just decide it on the facts of this case. But I do think that it's noteworthy that it does appear that at least some of the circuit courts that have addressed it, or some of the state courts that have addressed it, have flat out said that if it's an alternate that we're talking about, and no alternate ends up serving on the final jury, then it essentially is automatically going to be deemed harmless. Because
So in your situation, we could have even more overt discrimination on behalf of the prosecutor. And in excluding, say it was even more overt.
Sure.
But it's an alternate juror, and they never serve. So under your scenario, they could be, that would be harmless because they never served.
I think that is what many of the courts that I cited in the brief have held. Again, I don't know that we need to ultimately reach that issue in this case, because I think on our facts, they are strong enough to show that it certainly was harmless in this particular case.
But if we adopt the test, if we adopt the harmless error test, isn't that a potential application of it?
It is one potential application. I guess obviously this court would be free to fashion a harmless error test where it does look at more than just whether an alternate ended up serving. I'm sure there are ways that this court could do that and tailor it however you desire, because this is basically, to to my research, this is a first impression issue in Kansas when it comes to an alternate like this. But again, I think that for whatever reason, the court in this particular case chose to separate out the selection of the 12 and the alternates. I don't know that, I think it just probably by happenstance that in this particular case, it turns out that that does make it easier to analyze whether there was any impact from this. And again, our position is that there was not. And again, just to wrap up, the final point that I made in the brief is I think that we do need to recognize the distinction between a Batson violation on the one hand and an error in the procedure that was employed by the trial court. So here, to the extent that the trial court did err by not articulating a final ruling, that is not a Batson violation by the state. If there is obviously, if there's a Batson violation by the state, I would certainly acknowledge that, yes, that is something that is reversible and should come back. But that's not really what we're talking about here today. It's the process by which the district court ruled in this case or failed to make the ultimate ruling. So I would urge this court to keep that distinction in mind in looking at this, because I know that obviously Batson is an important tenet of the law, and we would never suggest that it's not, and we would never suggest that if a prosecutor discriminated on the basis of race, that we could just overlook that. But that is different than looking at the process here. And again, going back to Judge Klein's question, we think that the district court did everything right in those 3 steps. For whatever reason, he decided that it was not ripe to make the ultimate ruling, but our position is that the record here is sufficient to allow for review, because we see the reasons that the state articulated, and then we see the fact that the defense attorney never tried to challenge those bases when he responded and was given the opportunity to do so. So our position is that the record in this case is clear that any error that the district court made was harmless, and therefore we would ask that the defendant's convictions be affirmed.
Thank you, counsel.
Thank you, Your Honors.
All right, Mr. Schmidt, you have your rebuttal time.
Just briefly, if I can, because the thoughts are all over.
If you need a moment, we have plenty of time.
I'm not sure if a moment will clarify them.
Okay.
I wish, it would be a long moment. I think my argument is, well, first of all, the defense counsel did try to cut in and offer a little bit more. Could the defense counsel have, offered a lengthy statistical analysis? I mean, they can always do more. I've only done 1 trial, but it's hard. You gotta get in there, and the judges sometimes are terrifying. No offense or anything like that. But the defense counsel did say, Your Honor, if I may, here's some more information. I think that the judge still had an obligation to make a ruling, because ultimately the judge is trying to decide whether the prosecutor's purported reasons, even despite what defense counsel says. Defense counsel has the burden, but the judge still has to make a ruling on that, still has to decide whether the prosecutor's reasons are plausible or whether they're just pretext for discrimination. I'm not sure that the harmless error test, I'm not sure how to tailor a harmless error test to facts and then not get down the rabbit hole of looking at the outcome of the verdict. I don't know how that would be possible. It seems like the more you try to tailor a harmless error test, the more you're just going to be looking at, did it affect the outcome of the verdict, which overall is not the question for Batson, because we have this underlying equal protection principle here. And Batson talks about, this is about race, but you can't assume just because you have a white jury, they're all going to vote for white people, or you have a black jury, they're all going to vote black. It's tricky, because we're trying to prevent racial discrimination and get this cross-section of the community, but we're also not making assumptions that people of certain races vote certain ways. So I'm not sure how, it feels like if you tailor the harmless error test, you're going to start getting into speculating how people vote based on their race.
Well, I think what Mr. Maloney's saying, though, is that it's not a true Batson issue. That
Sure.
The court handled the Batson challenges, may not have ruled on it properly, but then it really is a procedural issue, not a true Batson issue.
And I think if that's, I mean, the district court views its discretion and made a mistake of law. And I don't think this court can determine that it was harmless because this court doesn't make factual findings. This court remands to the district court for that court to make the determination about demeanor and make that finding, as awkward as it may be procedurally. Unless your honors have any other questions, I'll just wait.
So let me just, let's, so your thought would be, come back, bring back all the jurors, I just want to walk this out.
Sure.
Bring back all the jurors, they're sat, put them in the jury box, have those 6 that were there, bring back the defense attorney, bring back the state, bring back the defendant, have the judge sit, and then recreate the argument of Batson? I'm just trying to figure out how you would do this remand.
I would look at State v. Bolton, pages, so that's 271 can, 538, pages 544. Well, I think it starts later than that, actually. 544 to 45. So trial court remand does not involve the presentation of further evidence, but argument. So they're going to bring back the attorneys, I think, the defendant, and they look at the record and counsel's recollection. So I don't know that they need to pull the jurors back in.
I wouldn't think so either. I would just
Yeah.
think they would just need the attorney, the state,
Yeah,
and the, would you bring the alternate jury?
I don't know. I don't know, because
You
that.
wouldn't, right?
I don't think I would, because there's a line in Bolton also that says something like, if the court can't determine whether it was a Batson violation, then a new trial is warranted. There's a line in there that feels very like, wow. I don't think so. It feels odd, though, because the harm is inflicted on the community, the defendant, but also on that individual juror that was struck. So it feels weird to not bring that juror back, but I don't think practically, I don't know practically how you would bring that juror
So
back.
you would just probably read the transcript and then from there make arguments.
Right, and then, yeah, the attorney's recollections, the judge's recollection, hopefully they have some recollections. It's the best, I think it's the next best solution, so,
Right, thank you very much.
thank you.
All right, we'll have this matter under advisement. At this time, we conclude this morning's docket. We'll be back at 1:30 for our afternoon docket. Thank you.
All rise.